If you're a software vendor, you have probably heard the term CCPA service provider or been asked about your CCPA compliance. You may have signed agreements using that label. You may have had customers send you addendums requiring it. But what does it actually mean to be a CCPA service provider? What obligations come with that status and CCPA compliance? What happens if you get it wrong? In this video, I'm going to walk you through the full picture of CCPA compliance, from how the law developed to what you're permitted to do with data to the enforcement scheme. The California Consumer Privacy Act was enacted in 2018 and took effect in January 2020. It was the first broad, comprehensive consumer privacy law in the United States, and it moved fast. The CCPA was passed in under a week to preempt a more stringent ballot initiative. Enforcement began in July 2020. In November 2020, California voters approved Proposition 24, the California Privacy Rights Act, or CPRA, which significantly expanded and restructured the CCPA. The CPRA created new consumer rights, tightened service provider obligations, and introduced data minimization and purpose limitation requirements. It also established a first-of-its-kind dedicated privacy enforcement agency, the California Privacy Protection Agency, or CPPA. The result is a dual enforcement model. The California Attorney General retains full enforcement authority. The CPPA, now the primary lawmaker and enforcement body, operates alongside the AG. Together, they have authority to investigate, audit, and penalize companies for CCPA violations. California now operates the most comprehensive and mature privacy regulatory system in the United States, and it is still evolving. Cybersecurity audits, risk assessments, and automated decision-making are active areas of rulemaking. Under the CCPA, a service provider is a company that processes personal information on behalf of a business under a written contract that contains specific, legally required restrictions on how that data can be used. Here's what surprises many vendors. You do not need to be a CCPA business yourself for the law to apply to you. The business thresholds are over $26 million in revenue, or processing data for 100,000 or more consumers. But service provider status is triggered by the relationship, not by your size or revenue. If you process personal information on behalf of a covered business customer, regardless of your size, you can be a service provider. This matters because a small SaaS company processing data for a large enterprise has direct obligations under California law. And a cloud hosting provider with no California customers can still be a service provider if it stores data for a California business. There is also an important distinction the CPRA introduced: contractors. A contractor is functionally similar to a service provider. It processes data on behalf of a business under a compliant contract, but a contractor must additionally provide a written certification in the contract stating that it understands the restrictions. If the certification is missing, the vendor is not a contractor and may default to third-party status. This is the heart of what service provider status means operationally. A service provider is tightly constrained in how it can use personal information. The regulations identify 5 permitted categories, and use outside those categories puts your status at risk. First, you may use the data for the specific business purposes identified in your written contract. Second, you may disclose data to subcontractors, but only if they qualify as service providers or contractors themselves. Third, you may use the data internally to improve or build the quality of your services. Fourth, you may use the data to prevent, detect, or investigate security incidents and fraud. Fifth, you may use the data to comply with legal obligations, court orders, or government requests. If you use data outside of what the law permits, your company loses its service provider classification. And therefore, the data transfer from the business to your company is treated as a sale under the CCPA. The CCPA and CPRA establish data subject rights similar to GDPR. The role of a service provider is to support your customers in fulfilling those requests. When a consumer submits a deletion, correction, or access request, the business instructs its service providers to act. The service provider does not independently evaluate or respond to the consumer. It follows the business's instructions. For deletion, the service provider must permanently erase the personal information from active systems, de-identify it, or aggregate it. It must also notify its own downstream vendors to do the same, cascading the deletion down the chain. For correction, the service provider must update the data as directed and ensure it stays corrected. This means correcting or monitoring any automated processes that might overwrite the correction. For access requests, The service provider must provide all personal information it holds or enable direct business access. Under the new CPRA regulations, you must cooperate with your customers' cybersecurity audits. You must support your customers' risk assessments, supplying all facts necessary to conduct them. Service provider status is also determined by the contract with the customer. If the contract is missing required terms, the vendor is not a service provider, regardless of how you handle data. The regulations specify what must be in a compliant service provider contract. The contract must explicitly prohibit the organization from selling or sharing personal information. It must identify the specific business purposes for which you're permitted to process data. It must prohibit use outside those purposes and outside the direct business relationship. The new regulations require you to provide the same level of privacy protection the business owes consumers. It must grant the business ongoing audit and assessment rights, at least annually. It must give the business the right to stop and remediate unauthorized data use. And it must require you to flow down all of these obligations to your own subprocessors. These core concepts are not negotiable in substance. They must be present. If your contracts are deficient, data transfers become a sale, and you lose service provider status. Service providers face direct and derivative enforcement exposure under the CCPA. On the direct side, service providers can be penalized for violating their obligations. This includes using personal information outside permitted purposes or failing to implement reasonable security. It also includes failing to delete or correct data or failing to flow down required terms. When a service provider exceeds its permitted role, it is reclassified as a third party. Penalties are up to $2,500 per violation and up to $7,500 per intentional violation. On the derivative side, a service provider can be held liable by its customers for causing non-compliance. If your actions trigger the business's non-compliance, you face significant contractual exposure. On data breaches specifically, the CCPA's private right of action runs against businesses, not service providers directly. But virtually every service provider contract contains indemnification obligations. If a breach stems from your security failures, the business will seek indemnification for its defense costs. Those indemnification claims can far exceed regulatory fines, covering attorney fees and damages paid to consumers. The practical reality is that the CCPA has transformed service providers into regulated compliance partners. The obligations are real, and the CPPA has stated that contract compliance and data governance are enforcement priorities. The CCPA's service provider framework is getting more demanding, and it continues to expand. Getting it right requires the right contracts upstream with customers and downstream with vendors. If you're a software company navigating CCPA compliance and want counsel who works in this space, I'd welcome the conversation. Please call, reach out by email, or connect with me on LinkedIn to stay in touch. Thank you for watching this comprehensive CCPA compliance guide. Let's connect to secure your compliance strategy.